Good evening. Can everyone hear me in the back? Andy, yes? All right, good. My name is Paul Ellis. On behalf of the New York Tech Alliance, pleased to welcome you all here this evening to our event, Top Legal Issues Around Global Expansion. Before we get into the event, we have a few preliminaries. First, New York Tech Alliance. We are a nonprofit industry association. We were formed a year and a half ago by the merger of Tech Meetup and the New York Technology Council. Our mission is to represent, inspire, support, and help lead the New York tech community and ecosystem to create a better future for all. We are over 60,000 members, and I will not be reading every slide. But I will read over this slide. Primary areas of focus: education, community building, workforce development, and advocacy. Dozens of events per year, largely educational events like this one. We also have our premier event, our Tech Meetup, and our CEO Roundtables. We are a membership and sponsorship organization. That is to say, we count on our members and sponsors to support the work we do in the tech community. So those of you who are not yet members or sponsors, we urge you to join in and to support our organization. Speaking of sponsors, these are the organizations that you would be joining if you were to become a sponsor of Tech Alliance. I will not read them all, but I will scroll through the slides slowly to give you an opportunity to see the great organizations who support our efforts. These are our annual sponsors. We have our founding sponsors. Wilson Sonsini, represented on the panel here today. Our annual premier sponsor. Our sustaining sponsors. Our supporting sponsors. And of course, a shout out this evening to Anshin, our host for this evening's event in this very cool space. Anshin is a frequent host of this legal track. This kind of feels like our home away from home, so we're always happy to be here. Anshin is an organization that has particular expertise in the tech space. We're happy to have them as a longtime supporter of Tech Alliance. And Chris, if you'd like to come up and say a few words, that would be great.
Thanks, Paul. Just wanted to give 2 minutes for a brief intro on Anshin. My name is Chris Noble. I'm a partner at Anshin. I head up our technology and software group. Anshin is a 350-person accounting firm with experts in many industries: real estate, financial services, construction, anything you can think of in New York. Our clients generally range from startups to growth stage to well-established companies, privately owned, VC-backed, and private equity-backed. And the services we typically provide for our tech clients are the R&D tax credit, which we do in-house, a test, which is audits, reviews, compilations, financial statements, tax work, exit strategies, international tax strategies, which I think we'll hear about tonight, and really just being that outsourced CFO for our clients and helping them, go through the process, especially as they, go through rounds of financing. So if you want to hear more about what we do or speak to any of my colleagues throughout the evening, I'd be more than happy to speak to you. Thanks and enjoy.
Thank you, Chris, and thanks again to Anshin. Our next scheduled upcoming event is, again, our premier event, our Tech Meetup. That's Tuesday, February 6th. You can register at nitech.org. So you are at one of the events of what we call our legal track. For the regulars, this is a series of events presenting legal issues of interest to the tech community. Past events have included sessions on structuring and early stage financing, preparing your company for an exit, and similar topics. Upcoming events include, in February, an event on data privacy and security, data security and privacy. In March, we're having an event on mergers and acquisitions for technology companies. April is going to be our annual VC update. May is an event on legal issues around wearables and the data collected by wearables. So we have a lot of interesting stuff coming up. If you'd like to be on our mailing list, please leave a business card with me or on your way out with Eric and Doug in the back. I will make sure you get on the mailing list. Also, if you'd like to get a copy of the PowerPoint this evening, similarly leave a business card and we will make sure you get a copy of the PowerPoint. In terms of introductions, again, my name is Paul Ellis. I'm a board member of Tech Alliance. I run the legal track, but I am the principal of the Paul Ellis Law Group. We are an 8-lawyer boutique firm here in Midtown. We do a lot of work with small and mid-sized tech companies and investors in tech companies. We work in areas including formation, financing, IP protection, licensing, employee matters, and mergers and acquisitions. We all come out of large firms, so we offer large firm expertise with the personalized attention and more reasonable cost structure of a smaller firm. Also, because of the amount of work we do with the community, we can often refer you to accountants, bankers, investors, and the like. I'm joined here by my colleague David Martin and Mark Coal. So we're very pleased to be here this evening. So again, our event this evening is top legal issues around global expansion, practical approach. We're really excited to have this event. I think it's a really important and timely topic. It comes up for my clients all the time. We have a great panel this evening. First of all, from Wilson Sonsini, we have Megan Bayer and Catherine Riley-Zakori. From Osborne Clark, we have Steve Wilson and Tim Resendez. Special thanks to, in particular, to Wilson Sonsini for organizing this event this evening. Our moderator is going to be Steve Wilson. I guess I'll turn it over to the four of you to introduce yourselves and tell us a little bit about your firms and your practices, and then Steve, will leave it to you.
Great. Thank you very much, Paul. Can everyone hear me? Is this microphone working? That sounds good. I've got a very loud voice, so if it's not, you won't probably tell the difference anyway. Thank you very much to the Tech Alliance for having us, and on behalf of Osborne Clark, thank you to Wilson Sonsini for including us on the panel. I think we're here just for my accent, so whatever I say, just ignore it. It's just the accent to make it sound international. But I'm Steve Wilson. I am Osborne Clark's resident partner in New York. Thank you, Paul. Osborne Clark's an overseas law firm, so the most important thing to say is that we don't practice any US law. We're all about the cross-border aspects of doing business from the US. So we have 25 offices around the world, about 1,600 colleagues, and all of them practice locally in whichever country they're located in Europe or in Asia. However, in the US we have offices both on the West Coast, where we've been open for coming up to 18 years now, and then we opened in New York 18 months ago. So the entire New York office of Osborne Clark consists of Tim and me. So we brought the whole office out tonight, and we're calling this the Christmas party. So we'll get into the wine later. I've been in the US for 10 years, so 9 of those, or 8.5 of those, over on the West Coast, working in Silicon Valley. So working with US tech clients who are doing business overseas. That's really from the point of expansion into a new market, right through to kind of expanding within those markets into different markets, addressing issues that crop up. And one of the things, as you notice from the title of the panel, is talking about practical impacts of expanding overseas. And the reason we say that is that if we were to sit here and talk about the detailed bits of law, and I know this is the legal track, you'd all we'd be fast asleep, but we'd be here for about 4 weeks going through every single country and the varying laws and regulations that apply, and honestly, that would exhaust my knowledge very, very soon. So what we're trying to do is we're trying to create a radar, and the radar really is based on our collective experience in advising both US businesses as they go overseas, and from a US perspective, which Wilson Sonsini will cover. So we've got basically both sides of the spectrum here. I'll pause there, because I have been told before I can hog these things. So I'll pass over to the other three to introduce themselves, and then we'll come back and get started on the panel.
Hi, I'm Tim Resendez from Osborne Clark as well. It's not too loud, is it?
That's good.
Okay. So I am the other half of Osborne Clark's New York office. We set up here about 18 months ago, and previous to that, I was at the firm's San Francisco and Silicon Valley office. I'd been there for about 5.5 years. Previous to that, I worked supporting Silicon Valley companies expanding overseas into Europe, trying to build tech ecosystems in Europe as well. So for about the last decade or so, I've been focused on helping companies internationalize. I'm a US lawyer by training, but everything I do, as Steve mentioned, we only practice internationally. So I really help to manage the international projects when a company is going into a country for the first time. We offer fixed fee packages to help facilitate that. They're really popular with fast growing companies that want a quick and easy solution to get up and running, go to market, build their business, and then over time we can help them grow along with them. I'll pass it on to you.
Hi, I'm Megan Beyer. I'm with Wilson Sonsini here in the New York office. We are, of course, centered in the Valley. It started in Silicon Valley in the late 60s and really grew up around the technology community there. So we only focus on companies in the technology and biotechnology spaces, and now the interesting space where they meet in the middle in digital health. And the New York office has been around for about 10 years. I focus in mid to late stage companies. So some of my clients, Flatiron Health, Yext, GoDaddy, and then some others on the earlier stage private company side. And then also some of the underwriter side pieces as well, like for the Trade Desk IPO and MongoDB. So some of those more New York specific companies. And this is my colleague, Catherine. And I will pass it to her to introduce herself.
I'm Catherine Riley-Zapori. I'm an associate in the New York office of Wilson Sonsini, and my practice is very similar to Megan's. We work with companies that are just forming, earliest stage of startup companies through public companies, working through every stage of financing that possibly exists, which now we're into like the letter N in financing letters. But beyond that, we really like to work with the tech community in New York in particular, and watching it grow and develop, and really taking its own shape apart from the West Coast. So we're excited to be here and to meet all of you and hear about your projects and companies and everything that you're doing.
Great. So one of the great things about the tech industry is that globalization is a natural part of growth, and sometimes we've found that has absolutely nothing to do with strategy, because being a tech business, being an online business, your customers can find you irrespective of borders. And so a number of the clients that have come to us over the years have noted that they never really planned to go overseas, but they suddenly have discovered that 5%, 10% of their customer base is located outside of the United States. And so depending on who their customers are, what their services are, what their products are, there is of course overseas regulation that may or may not apply to them. So not surprisingly, it is much better to go in with your eyes open, be a little bit proactive around it, and set up properly up front, because that's a lot cheaper than going in, making a hash of it, and then trying to correct it later. Obviously, from a legal or a lawyer's perspective, if clients want to pay us an absolute fortune to sort them out, that's great as well, but from our perspective, we're much more about getting it right first time and then growing, so that the overseas opportunity for tech businesses is a positive one, and not one that they kind of stumble into and then get upset when it doesn't work quite the same. So there's always a question about, are you just selling into the overseas market from afar, or are you actually setting up a business over there? So we're going to pick up on a number of different aspects of that tonight. There you go. So, Tim.
One thing too to note before we get into this, we would love for this to be interactive.
Absolutely.
So if folks have questions as we go through, please feel free to raise your hand, jump in. It'll make it better as you go on. We'll leave time for Q&A at the end too, but feel free to jump in.
Okay, so just to do some initial scene setting, you'll see we call this the European legal environment. In a lot of cases, our clients come to us to go into Europe. So we're somewhat using that as an example, but what we're talking about tonight, for the most part, applies in most markets around the world. We're speaking from a relatively high level, but for many US companies, the UK has been a traditional starting point, broadening out further into Europe, other places in North America, Asia, and so on. So we're looking at this both from the first step as a company you're making overseas, but also your longer term growth plan in additional markets you might be going into. So if we take Europe as a starting point here, we have 28 different member states, which with Brexit will be changing next year at some point. So what we have is very few pan-European solutions. Thinking of it as the United States of Europe isn't really applicable. You need to look at each country as a specific market and what you might need to do to deal with compliance or sell into that market. It's beyond that in terms of the cultural issues as well. So not only do you have different regulations if you're looking across the European Union, you have different cultures, different languages, different laws. So you might be aware there's civil law countries. There's also common law, which would be more like the US or the UK, something like that. So you have a whole different legal environment, both in terms of the way it's structured, the culture, and different states with different regulations, even though many times you have regulations that are European-wide, but they might be enforced differently depending on what country you're in Europe. So you always need to take that kind of local perspective on what you're doing. Turning to some of the great positive aspects of internationalization in general, we have a ton of competition for US investment. Everybody sees the great tech companies and other businesses that are being built in the US. They know they're going to go international. And just like you've seen with cities around the US competing for the new Amazon second headquarters, we see that from governments around the world. So they're seeking jobs, investment, and they have things like incentives, programs, and do a lot of hand-holding. So anywhere you take your company around the world, hopefully you'll find an open market for yourself, and you'll definitely have at least a government looking to help you there. Infrastructure-wise, if you're looking at Europe or some of the more established jurisdictions, you do have the same ease of infrastructure, typically easy to deal with as we would in the States. As we talked about, different laws across European countries, but as we're seeing with things like data protection and privacy, there's an attempt to at least make it relatively similar so you don't need to have a very different approach in each particular market, but at least have a more general approach that helps you do business there from the beginning. Obviously growing markets, so growing populations, growing markets. We see that in Europe, in developing countries as well. There's always going to be a market outside the US. And as Steve was saying, companies go international much quicker than traditionally. I mean, I think our rule of thumb maybe 5 years ago was seed round funded, taking a very proactive step to put a sales, marketing, customer service team on the ground in a new country. Now, your companies might have customers from day one, that are overseas. And then it's just a matter of, do you want to react to that growth? Do you want to go after it proactively? And so it's good to have these things on your radar at the beginning as you go to reach those markets. You might know that the US is known for being pretty litigious. We're known for having a lot of lawyers that like to sue people. When you step outside the US, it's an issue to consider, but typically things are handled in a different way. And so the fear of getting sued just generally is a bit lower on your risk profile as you're looking anywhere outside the US. And then looking at where you're going as a base for further growth. So that first step overseas can be going after that market opportunity, but then also thinking long term, where are you attempting to go beyond that, in that region or further afield? And then just covering quickly some of the things we're going to cover, you'll see the table, quick table of contents here. So we'll move on to the first big tip here, which is to prepare in advance. So anytime you're doing this, at least putting some initial thought into it, having a strategy, having a plan, knowing what success looks like, having metrics for that. How do you check that? How do you scale? How do you go to market? And then how do you avoid, some of the risks, getting in trouble or getting a big tax bill, whatever it might look like. So you need to think about it, on the business side, how are you going to approach that market? And then some of the issues we're talking about tonight more operationally, how are you going to do it correctly? So timelines are important. So things like opening bank accounts, you might have seen this in the US. There's a long process to that, even domestically. Overseas, it's the same issue. It's not in most cases, a 1-2 week process. It's a multi-month process and a lot of documentation, especially if you're outside the US, you might need to go in person to sign on the dotted lines, open that account. So we see bank accounts as one of the biggest issues to deal with there. Also, when you're hiring people, you're hiring outside your home market. It's a new place. If you haven't done it before, the process might be different. You're not going to have the same network you might have or the same advisors you work with. So that's something that can take time. And then the final point there is just always going to be unforeseen costs in anything you're doing as a business. So when you're overseas, the same issues might come up. So just building in some internal budgeting for some of the unforeseen things that might not be on your radar.
And one point on that as well, on the employee benefit side and hiring. I mean, keep in mind, right, as you explore hiring in different jurisdictions, that it's not just necessarily that your network may be different, but it's also the types of benefits that you're required to provide as a threshold matter will look very different. As an example, right, I mean, in the UK, there's the garden leave construct, right, which you need to get, what is it, three months? I wish we had that. A little longer. So a multi-month period before you're permitted to terminate an employee, right? Whereas here in the US, I think we're all familiar with the construct of a little bit of a different construct, right? At will employment. And so we want to be able to be ready for things like that, as Tim noted, because that's a very different approach to how you hire and onboard and then are able to get rid of somebody, really, if you have a situation that goes, not the way that you were planning at the outset. So just an example.
Yeah, and that's a great one. Dealing with overseas teams is one of the biggest challenges our clients have to deal with overseas, just because it's such a different environment. And we'll come back to that point in a couple of minutes and talk in detail. But just looking at the front end of it, doing your own research, taking proper advice, being thorough, and treating this not as, oh yeah, we'll just do things the same way over there. I'm sure it will all work, just according to plan as it would in the US. It's going to be different, but you need to take the same precautions and do things with a certain process that you might in the US. You wouldn't just hire somebody you met on the airplane on the way to a conference. You would go through a process, interview people, and make sure you're fully vetting employees or taking the right advice when you're in that market, when you are hiring or just getting started.
So I suppose the first question is, once you've decided that you're looking overseas, whether proactively or reactively, is like which markets are of interest to you? And I know some of the examples that we come up with this evening may sound a little silly to you, but believe me when I tell you that they're actually based on true examples where people have come to us with comments or questions that in this context will sound a little unbelievable, but things like, yes, I'd like to set up in the south of France. You're like, well, sounds a very nice area. Are you sort of, some sort of casino or some, beach resorts provider? No, we're a tech businesses. Or why do you want to do? Well, our CEO went on vacation there last summer and really enjoyed it. And you're like, that's probably not the best reason that you want to set up part of your business in that location. If France is the right location, which it may well be, then let's look at the markets. Let's look where you can actually find the right talent, and let's think about whether in fact that is the best location for you from a HR, from a real estate, from a privacy, whatever. There is a long list of questions that goes into where should you set up. And Tim mentioned a moment ago about second-hand advice. Do bear in mind that something that you might have heard or read, or one of your board members might have experienced 5, 10, 30 years ago, may well be out of date nowadays. So make sure that the advice that you take or the factors that you put into the decision as to where to set up are current. And talent is actually one of those big ones, because obviously the reputation of universities change over the years, and particularly from a tech perspective, there are certain countries that now have a reputation for churning out some really good talent, and there are certain Eastern European countries where a lot of engineers are now recruited at a fraction of the cost than the US, but provide a fantastic service over there. So you need to look across the board, and what you'll find that if you're getting advice either generically or once you start to look specifically, there are a number of governments that provide information through representatives in New York. So Finland is represented here tonight, and others, where you can actually get some market information and compare like with like, so that you can make your decision whether you're going into one country or the other. Business environment, logistics, where is the business? If you're going to be importing through the sea, a landlocked company is probably less great for that, but if it's in the middle of Europe, for example, and you anticipate where your customers are going to be, that might be great from a logistics perspective. Culture and language kind of linked together, and we've kept a whole slide for that for the end, which we never get to, but honestly, the cultural discussion and comparison is by far the most interesting part of talking about this, because it's honestly the one area that people stumble across and get wrong. It's so easy to get information online or through specialists that will actually educate you educate us all as to what's appropriate, what's not appropriate in a particular country. And the one I can always throw out there is from a British perspective, where if you're going to give your employees in the US, which has been a very trendy thing to do in current years in tech, you can have unlimited vacation. Take as much as you like, but of course, being in America, nobody takes anything, and the business doesn't have to accrue for it. If you tell a European employee, take as much vacation as you like, they will probably take 365 days of vacation because you've authorized it and you'll never meet them. So that is a cultural difference. We like our vacation, we like our time off, and whatever your annual entitlement, be aware they will take it. It's expected. You're expected to take your vacation to go away and kind of regenerate and come back afresh. Similarly, public holidays. We just had MLK. The number of emails I had from clients on MLK was amazing. So lots of people were working. In the UK, any public holiday, you're not going to get any emails at all. So just be aware of that, but also be aware of that once you have a team overseas and you're not quite sure why they're not responding because it's the middle of August and you have a factory in France, whatever.
So one of my colleagues who spends a lot of time in London doing the opposite of what these gentlemen do, which is European companies coming into the US. He said the first couple of years he was in the UK, right after the holidays, he's like, every year I would think, God, I must have had too much wine at the holiday party, no one was responding to me. And he realized no one in the UK will come back and respond to emails until next week. So he's taken the last 3 weeks prepping his email cache he's got 500 emails teed up ready to go out this coming Monday into the UK. So it's cultural things like that where you just kind of have to be aware that they're there. And the other thing, not to jump in on the cultural side, is that we find is always tricky is just because the UK speaks the same language does not mean it is the same culture. And that I think trips up almost every one of our clients that enters the UK. It is vastly different, and you would approach it very differently if they spoke a different language. You should approach it the exact same way as you would Germany, because you don't know the culture there and things are different. So keep that in mind, even if you do speak the same language. I think we have the same problem that comes up often in Australia. Countries that speak the same language do not necessarily have the same culture.
And as you'll experience tonight, our sense of humour is very different. We're jumping ahead to the third one, and then we're going to go back to that last slide because we've got it slightly out of order.
Yeah, so we just want to talk very briefly on something called permanent establishment that you might have heard of, and then we'll come back to what entities might look like and what type of corporation you might form in those markets. Because a lot of times what clients do is a company will start to have some contractors, start to do some business in a foreign country. They're starting to build up some type of operation, and very quickly the tax authorities are going to get involved. There, you might get a letter in the mail and say, we see that you are conducting some level of business here. And what it all comes down to is a test for having a permanent establishment. It's based on a number of factors. Once you do have one, you'll want to have an entity in that country. Steve will come back to what that looks like and what the triggers are. But really, a permanent establishment is the core piece to when you need to form that company, and it comes up over and over. It's a bit of a gray area knowing when that is because it's a number of factors. It's do you have significant business in that market? How many customers do you have? How much revenue do you have in that country? What type of offices do you have? Do you have people there? Do you have an office address? Do people have business cards? Do you have actual employees? Do you have contractors? Are those contractors actually more like an employee or vice versa? So there's a bit of a gray area. The more you have there, then the more likely you'll have a permanent establishment. And if it looks and feels like you're there and you're active in that country, you can pretty much assume that you do have this permanent establishment term. And so the tax authorities will get involved, and then it's time to form a company.
Almost like we rehearsed it. So if it's time to set up or register, then you need to decide what sort of entity you want. I'm a UK lawyer, so I'm going to talk about the UK, but every country has a similar decision to, you have similar choices and decisions to make in terms of what structure do you want. Sometimes it's tax driven, sometimes, particularly when you're just starting out, don't get overwhelmed with the tax position, because remember, tax only is relevant once you start making a profit, and we've seen many clients come up with fantastic structures when they haven't made a dime of profit and may well not for a number of years. So our advice is, until you know that you're going to have a decent market there, just do as simple as possible. And most people will jump to the conclusion, branch or subsidiary, well, a branch must be the easiest, right? Because it just sounds a bit simpler. And I'm here to dispel that myth. Almost always it's better not to have a branch and prefer to have a subsidiary. From a legal perspective, feel daggers over there about from a tax perspective, sometimes it might be better, but from a legal perspective, there are two reasons. Firstly, you're able to retain your liability for the overseas business within the subsidiary, and so if worst comes to the worst, then you can chop off, you may liquidate the subsidiary, and the liability, generally according to the corporate veil rules, will not come back up the tree to the US parent company. So that's kind of the most important one. Actually, if you're speaking to CFOs about the question, and you tell them that actually in a number, particularly of European jurisdictions, there's an obligation to file annual financial statements, and if you have a branch office, it is a branch office of the US entity. So it's just another little part overseas of the US entity. So any financial information that is required to be filed in country on behalf of the branch will be the financial data from the US. And since most private companies in the US do not have any such obligation, and therefore financial information is extremely confidential, CFOs usually say immediately, no, we're not doing that, because if you have a subsidiary, it's a separate legal entity, and therefore the financial data that you're filing at a public registry is that only of that overseas entity, and every single private and public company in the UK is required to file this annual financial accounts, and therefore you're on an even playing field, and you're not having to disclose the data from the US business. So pretty quickly you come to a conclusion that at least to start with, a subsidiary is the right approach. And actually, the majority of businesses, particularly from the US, will do that, particularly as it's going to be 100% a wholly owned subsidiary. So you'll have the US corporation at the top, and then underneath that you'll have the private limited company. That's probably good. In terms of plans for the future, that's when you might want to. So once you start to create some profits, that's the point at which I'm sorry. Are we doing cost plus? Cost plus is on the next one. So let me just pick that up very briefly. So if you have unused NOLs in the US and you're putting in place a sales office overseas, then a lot of businesses set up what's called a cost plus model, whereby the sales are done on the ground overseas, but the revenues, the contracts are concluded with the US parent company, the revenues can be recognized over here, and therefore you can often set off your unused NOLs. There are, of course, a number of hurdles to be able to achieve that, and tax advice it can always be sought depending on both the US perspective, but also where your overseas subsidiary is located. So bear that in mind too. The structure of subsidiaries will vary from country to country. Majority of European subsidiaries do not require resident directors. So usually what we suggest is that the US, two US officers get appointed as the first directors of the overseas subsidiary. Generally, we suggest that if literally you've just hired your new country manager or sales manager, whatever you want to appoint overseas, don't put them on the board right from the beginning until they've shown their worth and built up your trust. Being a wholly owned subsidiary, there is relatively limited liability or too burdensome director duties. So as long as it is run in the ordinary course of business and you're not doing anything crazy, then liability from the overseas director's perspective is pretty manageable. Other countries around the world will actually have resident director requirements. Singapore, Australia are two pretty popular ones, where either you need to decide to appoint your new person, or you can get a service provider to provide that sort of service. Yeah.
Have you seen any high revenue fintech companies trying to use Irish tax now? Meaning, despite wherever they're going, being in Europe, trying to kind of...
Yeah, so Ireland and the Netherlands by far are the two most popular jurisdictions for tax planning purposes. So there are, I suppose, two issues to look at, particularly from a fintech perspective. What's the local regulation? We'll get on to stuff about privacy a little later, which might have a factor. But other than that, generally, if you're looking at it purely from a tax perspective, the lowest tax rates for corporation tax tend to be in those two jurisdictions. So often you'll find, particularly when a business has grown a bit larger and has a number of different group companies, that you'll find the European holding company will be in one of those two jurisdictions. What, of course, you do need to think about is the other aspects of those markets, because typically in order to benefit from those tax rates, you usually have to have some sort of substance there, so that needs to be your local head office. So you need to consider, whether there's the appropriate talent there, what the tax implications will be for having people, or as Megan said earlier, kind of whether benefits work there, so that sort of thing. So that's why when you're looking at an overseas structure, a lot of people will come to a very fast conclusion based on, for example, the tax rate, and then you just have to think about it. That might be the right answer, but you just need to go through a bit of a checklist to think about other aspects of it, because if you're going to have a large employee base, then sometimes other jurisdictions don't work so well, partly because of the very difficult laws to part ways with underperforming employees. Speaking of which,
Yeah, and on Steve's point there, I mean, so much of it comes down to balancing so many factors that are involved. And every business is going to have different issues to consider, whether it's tax-driven, whether it's where your markets are. There's a number of factors. One of which is the employment environment, because it is so different overseas, and it varies greatly between different countries, even around the same region. So hiring, firing, attracting talent, retaining talent, it's so core to your business in the US, and it's going to be just as core overseas, but it's a very different environment. And so that is one of the biggest things that the companies trip up on, especially when they're just not as experienced in dealing in an international market, integrating an international work team, trying to compete with other big players in an overseas country to get that best talent. So this is a really important consideration. We could spend a lot of time on it, but I'm just going to quickly go through a few things. And when you're first looking at a market, there's two main approaches companies take, which could be sending somebody over from the US that you know well, knows your business, you trust to go over there and really kind of plant the flag for the company in that market. It can be a great approach, but then also consider that this person probably doesn't know that market very well. You'll need to get a visa, maybe a sponsor license in that country. There's some logistical hurdles in terms of payroll and tax withholdings and things like that you'll need to consider for that individual. The other alternative is to hire somebody local that really is the flip side of that. They know the market, they really know what they need to do to be successful there, but they might not know your business, your product, and they're also kind of very outside the organization. They're getting to know you, you're getting to know them, and so the way you grow that can be it just is so unique to what your company is looking to do, and maybe the people you already have or the people you're meeting as potential employees in that market. And sometimes a combination of the two works well. You send somebody over from the US to recruit the initial team and build that around them, to institute the right corporate culture, to really integrate them within the business and understand your product, the way you operate, and then try to translate that into a new country. And sometimes that works the best, but it takes some more investment to put more people on the ground to do that sometimes. When you do employ people overseas, you need to know that wherever that person is based, the employment laws of that country will apply. So you need to have a local employment contract. The last thing you want to do is send somebody overseas your standard 1 to 2 page offer letter with just a few terms, hopefully their name and how much they'll make and a few other things. Overseas, you're going to have it could be 10 pages, it could be 40 plus pages. And most of what's in there is protecting you as the business, because that employee, wherever they are, will likely have many rights that are by statute give them in rights that the employers wouldn't have, or they would have against employers. So in the US, we're seen as a much more employer-friendly. Most places overseas, this can be very employee-friendly. So the regulations there will protect them, and so that contract will protect you, because there is no such thing as at will. You would never want to just fire somebody if things weren't working out. There's a process around that.
Can I just mention, so if for any reason you decide to employ your overseas employee through your US corporation, that's absolutely fine. The employer can be the US entity, but the contract still needs to be a local contract. So it doesn't really matter who for employment law purposes, who the employer is named as. It's important that the terms are governed by local laws.
Yeah.
Why can't you just, there's websites like Upwork, are you familiar with those websites?
Are they a PEOs, go on?
Sorry?
Are they a PEO?
No. These are basically like websites where they're almost like an Uber. Say for example, I want to hire like a .NET developer or a Java developer. I can put my job spec up there, and I can find a guy there in Siberia or Pakistan or even Ireland or wherever, and he can do my work.
Mm-hmm.
So I'm actually doing business with Upwork, not this guy in Poland. So where's the risk on that? That's my question.
Yeah, no, it's a very good question. It's a very technical answer, and the issue, I suppose, is when you have a work for hire effectively. So there are lots of different jurisdictions depending on, lots of different regulations depending on which jurisdiction that guy is in. And effectively, he or she still has rights according to wherever they're located. It just depends on whether those rights are between you, sounds like it's not in this case, and them, or whoever the intermediary is. So what I suspect you would find is that if you were to do that, there'll be terms of service between you and Upworks, or the third party, that will say that if there is any liability caused between the employment relationship, it'll probably flow back to you, because in certain circumstances, those sort of arrangements can work out pretty well. Kind of if it's a limited project, or if you just have one person in a particular country that has an internal facing role or something like that. If it's a longer term role, and certainly if you start to have multiple people, yeah, exactly. Again, it's kind of like the permanent establishment. If it feels like an employee, it probably is, and that means that they will start to accrue rights. And I suppose the biggest takeaway is they will have rights, certainly compared with the US, where they have that at will, kind of like almost like a contractor type relationship. It obviously goes a little bit further than that. But certainly in the core kind of Western Europe countries, those rights that accrue, irrespective of what you call them or who the relationship is with, if they're working for you and they're working full time and you're giving them time off of vacation or paying them sick leave or whatever, they will be accruing rights. So it's usually fine until the point at which you want to terminate the arrangement. And then at that point, that's when you'll discover what actually the legal relationship was that you had with them. So, yes, but be careful.
Yeah, and a lot of what we're talking about here, the situation isn't necessarily cut and dry. We're setting up a company, we're hiring our first employee, or we're sending them over. This is kind of what we're talking about on the slide, but there's many situations that will fall into a gray area where you have a contractor, you're using a site like Upwork, and so it's going to be more of a gray area, and there's kind of balancing what that person's doing in a number of factors. Just going back to this one to cover a few things off here, as we mentioned, no employment at will is available really outside the US for the most part. There's going to be rules around things like notice periods, which is similar as well to like garden leave, which Megan had mentioned earlier. So there's typically a period built in where that employee still needs to work for you, or you retain rights with them. It's not just a standard 2-week notice, or not necessarily obligatory 2-week notice. They could go tomorrow. So
yeah, for the avoidance of doubt, both parties can agree to a shorter notice period. That's just the sort of the set period. So particularly if the company is looking to get rid of the employee, then that will be much more relevant than often the other way around.
Yeah, and in some cases we might also have pensions that you're required to provide, or sign the employees up for some sort of national system around that. It's not the same as the US, where you're not required to provide a 401k or anything like that. Benefits is something Megan had mentioned as well, but it's going to be really a balancing between what works in that market. So you're competing for talent with competitors there, but also making sure that it's somewhat in line with what you do in the US to help to kind of integrate them and not treat people differently around the company. There's a lot of balancing that goes into that. One of the big benefits, obviously, is stock options, and that's going to vary by country. In some cases, the tax is upfront, or it could be at such a high rate that it just doesn't really incentivize an employee the same way it does in the US, where it's core to seeking and retaining talent here. Overseas, it might not even work, and they'd say, just pay me more in salary or add some sort of commission or bonus structure. And typically, you might see the way compensation is structured is generally more salary, less commission, whereas in the US, it'd be a lot of commission or a lot of stock options as the real kicker there. And then there's a few things you can do to protect that, and that's having contracts for particular terms or having probationary periods built in.
And just to follow up on that point around stock options, I mean, it's not necessarily just from a tax perspective, it's also part of the culture, right? Which is, it's pretty common for here in the United States for employees to seek chunks of equity, right? I mean, it's very common for all of us that work in the tech community to see full stack employee options granted, right? Like even the lowest developer is getting, equity when he or she joins the company. That is certainly not the case, standard case in the UK. It's starting to roll a little bit more into that, but usually you're only seeing, equity grants to C-suite and top-level people. So that's a big difference, and that's not necessarily tax-driven. That's just a cultural thing. No one in the UK really wants stock options. They want the cash. So it's just something different to be aware of, again, from the cultural standpoint versus necessarily a tax.
Which is noticing the tax. I mean, the tax that will apply will be the local tax position of that employee. So that's going to vary from country to country, which is why it has a slightly different approach. We're running over time, so we're not going to dwell on these next two slides. As Paul said, we can share these with you. The point about consultants, contractors is pretty much it's the same, generally the same as the classification between 1099s and W-2s in the US. So, like I said earlier, if it feels like an employee, it probably is. But as well as back payment of payroll taxes and social security, there are of course those accrued employment rights which are likely to be a lot higher. If you do use a contractor and their role is to do sales for you, be aware of what's up there on the slide, the commercial agents regulations. Highly technical area, but it can result in the termination. If you were to terminate that contractor, that agent, receiving a kind of a termination bonus, if you like, or a termination payment based on prior year's commission earned. So somebody that you thought was kind of at will as a contractor suddenly ends up somewhat getting an employment sort of payment. So you won't know about it until it goes wrong. So my message is please take counsel up front. The other one we're going to whiz over because most people are familiar with it is if you're going to take real estate, whether it's a shared workspace, whether it's a longer term office lease, again, just be aware there could be some differences. A lot of the US shared office spaces you're familiar with in New York are now in London and Paris and Frankfurt and elsewhere. So there'll be a lot of brands that you recognize and it has created a much greater flexibility than used to be. If you have employees working from home, just be aware that there are a number of issues from a local regulation perspective you need to be careful on. Again, it's looking at protecting the employee having rights, and so don't assume that you're off the hook and you saved a load of dollars from not having to have an office space. That there may be issues that you need to check with your local employee that they have appropriate workspace, etc., etc. I'm on the right one. This one I'm also going to whiz through because I want to get to the next one before we hand over. This is all about IP. So generally for tech businesses, IP is the core of its value. You will have registrations in the US, usually patents, often trademarks. If you're going to start operating in overseas territory, be aware that those US registrations will not extend overseas. So you will need to re-register over in whichever area or jurisdiction that you're operating in. A lot of businesses actually will do global registrations right from startup. So if you've done that, you're good. But if you've not, be very aware, and particularly larger brands find that cyber squatters get in and start registering domain names and even corporation names, and they end up, starting their overseas journey by having to buy out names from people that have just taken advantage of the growth of their brands. So jurisdictions are very different, and some in Europe in particular, it's very often possible to get a regional-wide or an EU-wide registration rather than having to register in every single country. Sometimes that's cost-effective, sometimes not. It will depend on your market. What you and whether actually, certainly from a patent perspective, if it's even registerable. Right, we could be here for a week talking about privacy, but we won't be. I've got about 30 seconds to bring you up to date on GDPR and data protection around Europe. So, again, very prevalent in the tech industry. Data protection is huge in Europe. It has been for many, many years. And it's about to go on steroids. So GDPR, if you have an overseas business or you're selling into Europe and you've not heard about GDPR, talk to us, or at least Google it. So the big difference with this is that from the 27th of May this year, the whole of the EU, so all 28 European states who are part of the EU, which does include the UK, and the UK has confirmed that post-Brexit it will continue to adopt GDPR, will be subject to exactly the same laws. So at the moment it's a patchwork of data protection regulations which different depending on which country you're in, and my comment earlier about Ireland was that a lot of people who have a lot of data go to Ireland because the data protection regulator in Ireland is seen as a very pragmatic regulator, obviously because it wants to attract a lot of big tech companies, which they've been very successful at doing. Other jurisdictions like Germany, very strict data protection laws. What's going to happen with the GDPR is that we're going to end up with a single approach to GDPR. So actually the distinction between jurisdictions will fall away. The only difference is going to be the regulators will effectively remain the same, and you as a business will report to the regulator in your jurisdiction if you're only in one in the EU, or in your lead jurisdiction if you're in multiple, and the various guidelines in terms of how to determine that. So whilst it's going to be exactly the same laws, which will be enhanced from what they are at the moment, which of course covers things like the retention, the security, the collection, the destruction of data that you hold on EU citizens, then they will, if you have a breach or if you fail to comply with the regulations, your local regulator will have the right to take action. And the worst case scenario is a fine of up to 4% of global revenues. So it's global, not just within that one jurisdiction. Clearly, that could be quite a lot of money for a lot of you guys or a lot of the big global tech businesses. And so it has teeth, it's extraterritorial, can come outside of the EU. And the biggest change, or one of the biggest changes, is that previously it applied to a business that had a presence in the EU, so a subsidiary, employees, and activities there. What it's now extending to is if you're seen to be proactively selling into a market, even if you don't have employees there, and even if you don't have a subsidiary or a branch there, it can apply to you. So the same regulations will apply whether you have that permanent presence or not. So that's going to require some changes to your engineering, so that various consents are received. You need to understand where your data is held, how it's held, and individuals will have the right to bring requests to you to delete their data or provide you with copies of their data. And I'm told by people who are technical that sometimes can actually be it sounds an easy request, but it actually can be pretty difficult to do. So there is going to be a lot of changes, and we of course anticipate that the US business will have an example made of them by some regulator within Europe relatively early on in the adoption of GDPR. So lots of stuff to done. It's already too late to be fully compliant by May, but at least making some attempt to start to comply will put you in a much better position than many of your competitors who will be who won't have done anything at all or probably not heard of it.
And one follow-up point there, I mean, I think one of the big takeaways is, as Steve noted, they're going to most likely make an example of someone, and that the example that they make will be someone that has completely disregarded and flouted the GDPR, right? Which is, they will not have tried, they will not have put in any effort. The laws around this right now are fuzzy, and what companies are required to do to comply, I think, is still up in the air, as it often is with new regulation. And so it doesn't have to be perfect, is the message that we hear often, but it should be an effort that you're making if it is something that applies to you. So do not be the company that gets is made an example. Make some effort to comply with this if it does apply to you.
On terms and conditions, the only thing I'm going to say is if you sell direct to consumers, you will be required to localize your terms of service to wherever your consumers are located, and that may well be, that will include translating them into local language, obviously, local currency, that sort of thing. If your business is B2B, there is no legal obligation to do that. However, depending on who your customers are overseas, often there's a commercial persuasiveness around the negotiations that you will localize your contracts. So just be aware that that may not be another step to your globalization. And now to the US.
Great. So don't forget, right, that as you foray into the foreign markets, you are still a U.S. company, most likely. And so there are things that Catherine and I will run through on the U.S. side that you should take into consideration. The consideration about forming a subsidiary or not, I think Steve covered earlier, that the things that you're thinking about as you look into the foreign markets are what the board looks like. And so things to think about their composition. As Steve noted, sometimes you'll want to use U.S. persons for that. Sometimes the local jurisdiction will require that you have local persons that are on the board, not U.S. residents or citizens. Liability and how that will impact the board members. So thinking about who wants to take on that liability, who's willing to take on that liability, and investor controls. So, are there pieces of your, Series A documents or Series B documents that restrict your ability to create new subsidiaries and expand abroad? It's probably less likely that it's international expansion isn't a protected provision, but something like creation of subsidiaries is actually pretty common as you get into A and B plus rounds for protected provisions. And then thinking about finance and internal controls, which seems like it might be common sense, but as Tim said, don't do something in a foreign jurisdiction that you wouldn't do in the U.S. I mean, you're going to create this subsidiary that's going to sit, potentially a subsidiary or business that's going to sit abroad. You should be thinking about things like accounting, tax, and controls and how those are monitored and registered. And so as you think about tax structuring, I know Steve touched on that earlier, we try to focus pretty early on the tax side of things and how that's going to look, because it does tend to, although it's not the only thing that drives it, it does drive the bus most of the time. So make sure that stays at the forefront as you think about the creation of some type of subsidiary or some type of structure abroad. So from a U.S. perspective, don't forget there will also be application of U.S. laws, even though, go ahead.
Have you started looking into how the GILTI tax is going, under the new tax law, is going to be affecting these subsidiaries in terms of trying to move IP back and forth, and whether that's going to be a huge tax charge for the home company?
It's a good question. I think, as I said before, with new regulation comes uncertainty. So I don't think we have necessarily a definitive answer on that. I think we're still looking to see how it plays out. And the most important, or the thing that's come up the most, I should say, in terms of the new tax regime has been the consideration, actually the opposite way of what's referred to from UK perspective of coming in, or EU perspective coming into the US, of the US flip, if you're familiar with that, which is if you have a European topco and you want to start doing business in the United States, there are two common ways that you do that. One is you actually flip and convert into a US parent, and the other is creation of a US subsidiary. Usually, the U.S. subsidiary creation is for operational reasons, meaning I just want to start doing business in the U.S., right? The U.S. topco tends to be the result of an investor in the U.S. saying, hey, we'd like you to be a U.S. topco, we'd like to invest in a U.S. topco. And the main reason that people have given against doing that is, well, if I flip into a U.S. topco, I'm flipping out of a 20% tax regime and into a 35% tax regime in the U.S. That is no longer the case, obviously. So that bar has gone away. So I think that's the piece that we've heard kind of rumbling the most about in terms of the dynamic across the Atlantic. I don't think I've heard too much yet about the IP tax impact, but I'm sure that will settle out in the coming months. Yeah. So again, application of US laws, again, certain things are going to apply to you that may not have come up before. The most important of which is probably FCPA, anti-bribery laws, which is, again, you can't just park an employee abroad and expect to let them operate unilaterally without some type of supervision, whether you need some type of policy or some type of procedure, which you can speak with your U.S. counsel about. The policy procedure is a little bit secondary to what's actually going on over there, right? So don't forget, just sending somebody a piece of paper that says, hey, you can't bribe local officials, probably isn't sufficient, although that's great first step. You may need to do some training with that employee, talk about it. I think it's probably less common in the EU. I think it's common, much more common in the BRIC countries, and certainly in outside of Europe, but it's certainly something to keep an eye on. And then some of these other, we just kind of included a broader list of things to think about as you foray outside the US.
Another aspect of the expansion that you'll want to consider from a US perspective are your current commercial contracts that you think of for your US business and how your operations are running here. You may not have paid attention to some of these sections when you were negotiating the agreement, but there could potentially be territory restrictions, non-compete provisions, and exclusivity provisions within your existing contracts that slipped by you when you were reviewing those at the time and you thought, that doesn't matter to me, but it could come up now. Just as an example, I dealt with a client a year ago that was not ever thinking about expanding. It was a beauty company, and then they started to realize that they had a pretty substantial market of customers that were in France. And they went to move to France when they realized that one of their largest suppliers had an exclusivity provision only for France that they hadn't paid attention to, because that company had a subsidiary in France that also did the exact same supply as they did for them in the US. And they ended up tripping that provision and breaching the agreement. And it was a complete accident, but they just hadn't paid attention to it before. So being aware of what your existing contracts say. And then looking at, we've kind of covered this, so I'll gloss over it very quickly, but consider the impact of culture. Yeah.
Just going back to what you said, if you do business through channel partner channel, does this, like for example, I don't know, you're a US-based company and you would like to do business in Russia, but you're using a partner over there, and you don't open a subsidiary. So will you be subject to any law or restrictions?
Would you be subject to the restrictions through your partner?
Yeah, well.
Or restrictions of your commercial agreements?
Restrictions from US doing business in Russia, for example.
So it would depend on what your existing contracts say, particularly with that partner, because if you are looking to do business separate and apart from the partner, chances are you're breaching some sort of
you just have you have a reseller in Russia.
There's like indirect competition.
So yes, you would be subject to the regulations and requirements in all likelihood. I can't speak to Russia specifically, but
well, no, but I think what you're asking is in the US, if in Catherine's example, so if you ended up rather than you doing business, but you have a partner there that's doing business in breach of the US contract, I think that's what you're saying, then
Yes.
presumably if the contract said direct or indirect competition, then yes, you would be in breach of it.
Yeah.
You don't have to do it yourself, right?
That's right. Yep. So then going back to culture, we've covered this in quite a bit of detail, but this is specifically talking about your company's culture. That going abroad, you want to keep in mind how that will affect your U.S.-based employees and your U.S. company. You've spent a lot of time curating a culture of the company here, and when you're bringing in employees from different actual cultures around the world, that's going to also infiltrate the company culture and how your current employees are going to react to the expansion. What opportunities they may have, what titles you have, because internal titles are different from one country to another. So that'll be something that the HR team in particular will want to consider and preview for the current U.S. employees, so that nobody's feeling like their toes are being stepped on. We've also touched on this one quite a bit, but risks to your established U.S. IP. You'll want to consult U.S. IP counsel just to make sure that everything that you already have registered here is protected and shielded from the work that's going to be going on abroad. It is important to protect your IP in the new countries that you're expanding into and new jurisdictions that you're expanding into, but you also want to make sure that nothing that's happening abroad is infringing or exposing the registrations and the IP that you have here already.
And we're just going to continue to beat cultural differences over the head. So this is just a little bit of granularity around the communication styles, which are a little different. And the example I always give is, in the US, every meeting I have is assumed to be 30 minutes. In the UK, every meeting I have is assumed to be an hour. So, you know, as it says here, US, direct and efficient. Everyone wants to get in and get out very, very quickly. You are talking 15 to 30 minute meetings, in and out the door. UK, indirect and relationship driven, right? That those hour-long meetings are spent, they're hour-long because the first 30 minutes is speaking about how your holiday went, how your New Year was.
The weather.
Yeah, how horrible the weather is in London. So keep that in mind. Again, EU, more direct, relationship driven. Asia, hierarchical and relationship driven. So these are just some guideposts around some of the more high-level cultural points that we've been talking about, but just a little more granular around things to keep in mind. And I think we've pretty adequately covered these other points on
And I think on that first point, we tend to think of it in an internal kind of basis, how you would connect with your teams overseas. But bear in mind that it will, if I turn this off, I have. But bear in mind that it will also apply to the way in which your overseas employees are dealing with your ultimate customer. And we've found that a number of times over the years where obviously sales in the US are driven pretty quickly. I mean, you'll meet someone, you'll do the sale, and it's like on to the next one. Whereas in certain overseas markets, it may well take a lot longer to develop the relationship and convert the sale. But it could well be that that customer is a lot more loyal because you built that kind of personal or deeper relationship than, say, in the US, which where a customer may be loyal until the next person comes along. So what we've seen there is, if you're launching for the first time, it's worth giving some thought to what that kind of sales cycle is likely to be, because you might need to build that into your forecast, certainly your patience, and the worst case scenario is you say this hasn't worked at all. You shut it down at 11 months after launch, and then you actually find that if you'd waited that extra month, you'd have had the most loyal customer base you've ever had. But because of the difference in culture, there's just been a decisions taken a little too quickly. We're going to pause there just to open up for questions, because we obviously want to end promptly, and very happy to take a variety of questions. Yeah.
Mine is about intellectual property. What if you have a trademark in the US, then you move to Europe, and then that trademark, you cannot use that trademark in Europe? How do you deal with that?
You're either going to challenge the trademark in Europe, and it has the same classification systems as in the US. So if you do have somebody that has the same trademark, you first of all have a question of whether you can somehow bring an infringement action. However, it may well cause you to have a different brand, and I think on Catherine's slide there was the talk of a global brand. Clearly that's generally what you want, but there has certainly been circumstances where you've had to change the brand. That might be for that reason. There's some much better examples where brands don't work in different languages. One of the ones these guys have heard before is Chevy in Europe basically launched a brand of car called the Nova, which was very, very popular, particularly in the UK, and they went to launch it in Spain. And for Spanish speakers in the audience, you'll understand that Nova is not the best description for a car. It says it doesn't go, it doesn't work. So not surprisingly, they had to change the name of that model in order to work within that local market. So it's important that obviously legal issues are one thing, but the marketing team and the branding team needs to be very much involved before the launches of other brands and products overseas. Didn't you have a good one as well?
Yeah, no, from our perspective, the interesting thing is on the trademark side of the house, especially for startups, unfortunately, of course we tell everyone, hey, register your trademarks, get them protected, right? But the flip side of that is it's really expensive to prosecute a trademark. And if you're tech company, like spending money on prosecution of a trademark is probably, way down on your list of things to do. So a lot of times it's a win in the market type of approach, at least in the US. And so, whether you have a conflicting trademark abroad, somebody else has the same trademark or something close, I can see a very similar practical answer being, go out there and win in the market, and then people will recognize that it's you versus somebody else, because it's really expensive to prosecute that here in the US. I wish I did have a good one, Steve. I don't recall that.
Isn't it like Burger King in Australia? Isn't it like Hungry Jack's or something like
You're
that?
right.
Yeah.
And is that? I think that's because there is
There
like
is
a
Burger
tiny
King.
little a store somewhere that's called Burger King, right? Yeah.
My favorite store is TJ Maxx, which in Europe is TK Maxx. The exact same fonts and everything, so you definitely can still recognize it.
But there are issues that could be created from that, just because there's it doesn't have to be registered IP in Europe in order to bring infringement actions. You can have the look and feel. But I think Cinder over here, maybe. Yeah. Passing off. That's what it's called. Yeah.
In the US, you've got obviously workers' insurance. Now, as an IT company, we sometimes work with third-party companies out in India who are basically subbing through our services. Now, how do we sort of say, well, our insurance company will cover our US workers, but they're not going to necessarily cover these Indian workers? How does this sort of like work with with things like insurance?
The first answer to your question will depend on what the local regulations require. So I think workers' comp is an obligation over here, right? You have to have it?
Yep.
Correct.
Yeah. Okay. Overseas, that's not necessarily the case. It will depend from jurisdiction to jurisdiction. So like we were saying earlier with the employment laws, it's definitely worth checking out, both in terms of your obligations, so your insurance requirements, but also, I think we picked up a few times the benefit side of it. So understanding what's market, both from an expectation perspective as well as a legal perspective, is important. If it's decided that you do want to have insurance for your Indian employees, then there are a number of insurance products that will apply globally. So speaking to your broker in the US is the first suggestion, because obviously an extension to your existing policy is the easiest and often
Getting
the
a
most
rider is the easiest for one-off countries, is probably the most efficient way
absolutely.
to work it.
Otherwise, you just have to go into market, and again, it will be more complicated, but it's certainly possible to source that sort of product. Yes.
Hi, I just thought I would add, your presentation was absolutely fascinating. I've been involved in European and U.S. Business operations for a couple of decades, and you guys touched upon the local knowledge versus the company knowledge, and that was really good, and of course everybody emphasized the cultural stuff. I just wanted to add that one thing that I found through experience is that don't forget the lower level staff and employees, because a lot of times you're just, okay, well, the managers have got to understand each other, the foreign managers got to understand the company culture, et cetera, but don't forget those people further down the line, because they're the ones that are actually going to make it work.
Yeah.
Yep.
And one of the things that I found has been very successful, at least for the first couple of years, and it's also great for morale, is to do like 6-month exchange programs with the lower level employees.
Yeah.
There's nothing better than getting your employees revved up by saying, we're going to send you to Budapest for 6 months, and the Hungarians say, we're sending you to New York for 6 months.
Yeah.
That's great morale,
Absolutely.
and it really is practical.
I completely agree with that. I think one of the slides that we skipped over very quickly had something about team dynamics. 2 quick things. If you do those exchange programs, please remember you will need a visa for that employee unless they hold a passport for the destination country. And if they're going for any longer than 6 months, you need to think about secondment letters for them, because otherwise they will start to inherit or be subject to be protected by local regulations, even though they may well be employed in the US. So, and tax becomes an issue, but you're absolutely right. And I think one thing that often we hear, kind of from the flip side, from the overseas teams, are the US management, or we have these team meetings by video, they've no idea that the time they set it for on a Friday is 6 p.m. our local time. We're ready to go away for the weekend, but they're only at lunchtime, or of course from the West Coast it's in the morning. And so there's a lot of these things that don't necessarily occur to managers or people setting up these sort of meetings. And come back to the public holiday point I made earlier. It's like, just be aware that that it can be very countercultural actually if you start to enforce or suggest meetings at unsociable times because of time zones.
We've actually had a couple of clients that have said that recently, that they thought, we're in the UK, we're going to approach the US market, we'll set up in the Valley because that's where everyone is, they're in the Valley. And then, like 6 months later, we're like, this is just not working. The time zone is just not workable. We thought we could do it. It's not going to work. We're going to either have to leave the US, seriously, we're going to leave the US market, or we're going to have to bring people closer to London, back to New York to make it work. So I found that to be really interesting.
For 10 years I had that time zone difference with our headquarters, and I love being halfway now, but at least we've got half a day overlap. Any final questions before we close it out for the night? No? Well, thank you all very much. Obviously, as I said at the beginning, we could go on all week about this sort of stuff. So appreciate you listening, and thank you for the questions. And obviously, if you need any support, both teams here would be more than happy to speak some more, and we'll obviously hang around a little bit at the end. Thanks, Paul.
All right, Steve, Dan, Catherine, Megan, thanks very much. Thank you for a really great event, a really informative panel. So our panelists can be around for a little while if you want to come up and speak with them. Otherwise, if you'd like to get onto our mailing list, make sure you leave a business card with Dee or with Doug or Eric in the back. And we look forward to seeing you at one of our upcoming events. Thanks very much.